Our resident lawyer Despina Priala of boutique law firm Priala Legal in Runaway Bay is with us every Thursday morning to offer her legal expertise by providing some general advice on the latest hot topics. We do have a couple of hot topics this morning. She has experience spanning more than 25 years in the area of property and commercial law. She joins us now. Morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning. So last week we spoke about combining assets and updating your will. Following on from that, an interesting article was released about Magistrate Rodney Higgins, whom just won his young court clerk's super benefit. So this case can apply to almost all of us in regards to super and who it will go to if you do pass. So what happened in this particular case?
It is an interesting case, as you say, and I'm sure a lot of people, when they read that initially, particularly with the headline and the contents of the article, would have said, oh, that seems a bit unfair, doesn't it? They only were together for 4 months in a relationship, apparently. Him being 45 years older, I mean, that, has other issues perhaps as well, but it wasn't at the heart perhaps of this particular matter. But she left her superannuation benefit. She named her mother as the actual named beneficiary, and the magistrate, in this case her partner, de facto, I'm presuming, of course, made a claim and said to the trustees, well, actually, I'm entitled. I want the money, and the mother actually missed out. And so it is an interesting case. I think it's perhaps unfortunate in this particular scenario. So we can talk about what probably or may have occurred as to why we have this outcome. And it's really important because we've talked before on the show about binding death benefit nominations with your superannuation fund and how they generally work in terms of estate planning. So if we talk about some of the things, it'll become evident perhaps of what happened here in this case, if that makes sense. So what happens when you have a binding death benefit nomination or even a non-binding death benefit nomination? You nominate a certain person to receive that benefit. Now, under the particular act that they talked about in the article, called the Superannuation Industry Supervision Act, 1993, it's very clear there as to what they say about who is entitled to receive this type of benefit. So for someone to go to their fund and say, look, I want to make a binding death benefit nomination or nominate a particular person as my beneficiary, that person has to be an eligible beneficiary first. So it's got to be someone that fits within the Act, otherwise it's not going to be valid.
I think this is something that a lot of people don't realise, that you can't actually decide, that is, there are only a limited number of people who are eligible for your superannuation.
Exactly.
You can't just say, I just want to nominate, some friend or, someone from the past, my cousin, whatever. There are only a certain number of people who are eligible for your benefit.
That's exactly right. So when you go and make these particular nominations, you really need to get advice and make sure that the people you nominate are eligible. For example, specifically in the Act, you are entitled to nominate your spouse, child, or dependent. So when we go through each of those, a spouse does include a same-sex partner and de facto partner, okay, as well as obviously married couple. So that's what spouse includes. A child is a child, of course, and dependent is the interesting one here, because when we look at this scenario, the mother was not a spouse, the mother was not a child. So she would have to have fallen within the category of dependent. And here they determined that obviously she did not. So, and the definition of dependent is quite interesting, because the Act talks about having an interdependency relationship with that party. And there are a number of factors that they've got to tick off. And they don't have to be family. So it can be someone who, and generally has to be someone that, yes, you have a close relationship with, that you live with that person, that there is this financial dependency. So there are items that have to be ticked off as per the legislation.
Yeah, so immediately I'm wondering, why on earth didn't the super fund tell her this when she was nominating someone that wasn't eligible?
Yeah, you'd have to wonder what happened at the time that it was made, right? So, and sometimes people do it themselves. You see, they get the
Online
form,
or,
yes. So binding death benefit nomination forms, if this was indeed a binding death benefit nomination, you can get them off online. You can download the form and you can fill it out and submit it to your fund. Okay, so that's a little bit dangerous.
Oh, that's so
Yeah,
dangerous.
so nobody checks it. So you can just hand it into your super fund and they'll say, yep, sure,
Cool,
no worries.
thanks, we've taken it.
Yeah, and it's not until you actually get to the payout that suddenly you realise there could be a problem.
Well, that's the critical thing. So the fund there, they probably should, but they're not going to say to you, yes, well, we're going to check off and make sure that person's eligible. That's not really what they do. Perhaps they should, but more important, I think that if you go down this path where you want to do this, whether it's a binding death benefit nomination or even a non-binding, and you choose when you decide to do this and nominate a beneficiary to take your benefit, then you need to get advice and you need to make sure. So I've said to clients before, they've actually just turned up at my office when we've had a meeting for estate planning issues, and they've said, oh yeah, well, here is my binding death benefit nomination form. I'm going to sign it, can you witness? So they haven't discussed it with the fund yet. They've just downloaded the form, and then we talk about this. And then we talk about, all the ins and outs of what this means for them from an estate planning point of view. And it's really important because one of the main reasons why people do make binding death benefit nominations, which means the trustee generally is bound by what you've put in the form, unless in this case you see that you've completed a form but the person's ineligible to receive the benefit, which I suspect is what's happened exactly here, then you go through that process and you complete all of that. And the main reason that you do it is because you're trying to protect that asset. See, because when you make a binding death benefit nomination, the idea is that whatever the value of the asset is, in this case it was 180,000. It could be 3 million. I mean, who knows what it would be. It goes directly to the beneficiary. So it's paid directly to that person. It doesn't come in to the estate. If it comes into the estate, then it's liable for or up for grabs in an estate fight if someone lodges a claim against an estate. So we're talking about testative family maintenance provision applications. Someone wants to lodge a claim to say, I didn't get anything from the estate, or I didn't get enough from the estate. They make a claim. But if you have a binding death benefit nomination over here and it's valid, the trustee accepts it, it's paid direct.
Yeah.
So that, say if someone passes away and their main asset or their only asset is that particular benefit.
And what about a non-binding benefit nomination? What does that mean?
So the difference between binding and non-binding generally is if it's non-binding, the trustee has a discretion to decide if they pay the benefit to the person you've named in the policy.
What else could they do? What are their other choices in that case?
Well, generally, they will pay it to the estate, right? So they pay it to the legal personal representative, and then it gets forwarded out through the estate particulars. Usually the trustees will determine if they need to exercise a discretion when someone puts their hand up after someone passes away and says, I want to get that asset. I'm eligible. I want that money. And then the trustee puts a hold stop on the whole procedure, big hold, and then we have to deal with this dispute at hand. So the binding death benefit nomination does mean that the trustee is bound to follow the nomination, subject to the actual nomination being valid, yes, meaning you've picked someone that's eligible, and you've got independent witnesses who witness your signature, and it hasn't lapsed. So there's a few things you've got to sort out. Generally, every 3 years, if you've made a binding death benefit nomination, it does lapse. So you if you don't know about that, you need to, and you need to find out from your fund if you have an option for a non-lapsing binding death benefit nomination.
Will the superannuation fund send you perhaps send you a text message or send you an email or send you a letter saying you need to renew this?
I would love that. Wouldn't that be good? Getting a text from your
Nice.
super being like, hey Brookie, like, do you want to update this?
Exactly. They should perhaps. It's questionable, but I wouldn't like to hang my hat on that when I make a binding death benefit nomination and go, you know what? Okay, the fund will call me in 3 years and I won't have to worry about it again. You need to diarise that for when it lapses, when it expires, or prior to the date, to make sure, yes, I still want this in place. I'm going to go to my fund, I'm going to renew it So it lasts another 3 years or whatever the period is, because these laws are changing all the time. So it's important to keep that up to date. Plus, the person you've nominated, say 2.5 years ago, maybe they're no longer in your life. Maybe they've passed away. So you need to even look at it, review it, at the time it's due to lapse, and make sure it's exactly what you want. If you don't do that and you fail to do it and it lapses, it does mean it gets paid into your estate because you've got no named beneficiary. And then you have to say to the person, well, is that really what you intended with this nomination? So it all comes down to proper estate planning and getting advice up front and not doing it yourself.
Yeah.
Just to save a couple of bucks. And I have to say it that way. We talked a few weeks ago about that topic of, you pay
Spend more time.
peanuts, you get monkeys,
Yeah.
with perhaps property matters. So it's the same with estate planning.
Maybe we should have that option taken out where you can do it yourself. Maybe you shouldn't be able to do that.
No. If you can click a form and just hit submit,
Yeah,
and
that
that
would
is
make it so
your
much easier.
life savings,
Yep.
possibly it's disastrous. Well,
Yes.
that is Despina Priala from Priala Legal in Runaway Bay. Coming up next, we're talking about the rollout of the voluntary assisted dying bill. Stay tuned.